Are we ready to start?
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Wolohojian and Sachs. We are meeting self-evidently by video conference rather than in person in light of the pandemic. However, the rules of argument remain the same. It's 15 minutes aside with no rebuttal. We have read your briefs and are familiar with the arguments. And I should say we appreciate counsel's willingness to reschedule in light of last week's closing of the courtroom in memory of our late and great colleague, Chief Justice Gantz. So with that, our first case is number 18-541, Commonwealth versus Tyrone Martinez, and we will hear first from Mr. Michal.
Good morning, Your Honors. I represent Tyrone Martinez on appeal. The first issue, well, there's three issues in this case. One is speedy trial. The other is with respect to incidents that occurred, the defendant believes too remote in time to have been admitted. And whether or not the elements of conspiracy had been met. With respect to the speedy trial issue, although it's somewhat convoluted, it's a very lengthy docket in terms of dates, and somewhat convoluted in terms of when things took place. In my brief, I outlined that it appears that there is in excess of 500 days from the time, from the time that he should have been entitled to a trial. On, I believe it was the date. I apologize. Looks like the date. Well, I apologize on the date that the trial counsel requested no more further continuances. But as of that, on that date, when the trial counsel did request that there be no more continuances, and noted for the court that the Commonwealth had the opportunity to provide, immunity to the witness that they were having difficulty securing, the judge did note that he also was having some difficulty with the 6-month request by the Commonwealth. Then subsequent to that, there was another continuance, but on the record, there's nothing on the docket. There doesn't appear to be necessarily any notation as to why or.
The issue I have with this, Mr. Michaud, if I may interrupt you, I'm sorry.
Sure, no problem.
It seems to me that if we exclude from the moment of objection, May 19th, all the way through, include from the moment of objection, May 19th, all the way through the trial date in March, there are still 242 excludable days from September 21, 2015 to May 19, 2016, and that we come in at a number under 365 days. Do you agree with that calculation?
I don't, but again, I'm not, I'll defer to the court if the court determines that that's the amount of time. I had difficulty with calculating these dates. I don't think it was an easy task. It is a little bit convoluted, but again, I will defer to the court if the court, I believe that it's more than 365 days.
May I ask you a related question, but slightly different? What do you say to the Commonwealth's argument that you've, in essence, waived this issue by not filing a motion to dismiss down below? I mean, I recognize that you're maybe hampered by the lack of certain notations on the docket. There's some things not reflected on the docket that we might wish we could see. For example, an actual action on a motion to to extend the time or defer the trial, but we also don't have any indication that the defendant objected beyond the one that you pointed out to in your brief. And so at some point, does this become a waiver if it's not raised down below?
I read the Commonwealth's cases, and I don't believe it becomes a waiver, but my understanding from Commonwealth versus Graham is that the defendant doesn't have to raise an objection every single time, and he did raise the objection and the objection to the continuance on the record. You know, whether a formal, I don't believe a formal motion to dismiss is the
What
the
happens?
real issue. But again,
What happens if he files a motion for something, a motion of some sort, after he has asked that there be no further continuances of the trial date?
Well, I suppose it would depend on the type of motion. But again, I guess there also would be any delay period for the ruling or determination of that motion would certainly be taken into the calculation. But again, I think it goes to what that motion entails too. So again, it is a difficult record or docket to interpret. But I would again suggest that it appears to me that it's well over 365 days. And I don't believe
when you say it appears to you that it's well over 365 days, doubtless more than 365 days passed from indictment to trial.
Correct.
That's clear, almost with 600 something days passed, clearly. But then there's the question of what we're supposed to exclude from the count. And what I'm saying is, if we exclude up until the moment he objects in May, if we take everything else either to be jointly asked for or acquiesced in from September 21, 2015, which I think is the date of indictment, to May 19, 2016, if we exclude those days, which are, I think, 242 days, my calculation is that it's only 360 odd days, 360 or 61, I don't remember, days that are includable, and that's under a year. That's all I'm saying. Do you, I mean, first of all, do you disagree that we include from September 21, 2015 to May 19, 2016?
I'm sorry, do I disagree what again?
That those are includable.
Excludable.
Backwards. Excludable.
I don't believe that all those days are excludable, but I would say that any dates that were either jointly continued or the defendant requested continuances, those would be excludable. I don't believe all those dates that you're referring to are excludable, but again, I'll defer to the court. That's, I guess, I think an issue is with respect to, what is determinable as far as being able to calculate these days, what is specifically excluded and not.
Well, isn't that one of the reasons that we want these claims brought in the trial court, so that the judge who's been with the case or the judges can make these findings about what's excludable and what's not, and determine facts if necessary. Whereas when it comes to us just on this sort of record, it's very difficult, and that raises the waiver question.
I don't know that I don't believe it would be a motion for new trial or the trial counsel's. Again, I could be wrong here, but I don't know that is the trial counsel's. That was his responsibility to ask. I think that I don't know that the appeals court is in any different position than the trial court to determine this docket. I can't see how multiple judges would be able to determine at the trial court level, these missing notations that we're talking about and why things seem to happen. I think what's important is that the trial judge, I believe it was in the summer, had discussed that this continuance of 6 months was concerning to him, and so that I think is also beneficial to the defendant to show that there is a potential problem here. Again, the calculations, whether I am wrong or the court is right, I don't know on that. I can tell you that based upon my calculations, the way I see it is that it's roughly 500 days. But again, you know, I could be mistaken. And I'll certainly defer to the court's calculations. I just believe that it's in excess of 500 days.
May I ask a question about the prior bad acts?
I'm sorry.
A prior bad act.
Yes.
I didn't see where an objection had been preserved to either of those. I know there was a motion in limine, but it wasn't finally ruled upon. The judge said he was inclined, I think, to let some things in, but that he was going to keep an open mind. And when the issue arose at trial, I didn't see an objection. So I'm wondering if the whole issue as to both prior bad acts is preserved, or whether we just review for substantial risk.
I believe from my memory is that it would be preserved for the substantial risk. I believe you're correct in that there wasn't on the record an objection. I can certainly go back and look at that.
Could we turn to your argument regarding the sufficiency of the evidence?
Certainly. I'm sorry. Do you want me to discuss that?
Yeah. I take it that your contention is that there was no evidence from which a reasonable inference could be drawn that the defendant and his girlfriend had an agreement with respect to the intent to murder piece of the charge, that whatever their agreement may have been, it was not sufficient to infer an intent to murder, a specific intent to murder. Is that correct? Am I correct in understanding your argument?
Generally, my understanding from the facts is that that the girlfriend had posted these Facebook chats. I don't belong to Facebook, so I don't know how those work, but she posted these Facebook chats to someone she had met, who the defendant also had known from these prior incidents. And it appears that she didn't necessarily know what he was doing this for, that she was just kind of obliging or complying with whatever he asked her to do. And the same seems to go for the fact that on the drive to this victim's location. So I don't see any evidence of that, other than just kind of following along, that there was any kind of agreement.
Well, you would agree that there was evidence that there was an agreement among them to set up an encounter with the victim.
Certainly, a meeting, yes. So, yeah.
An encounter. Let's just call it an encounter.
Sure.
Okay.
Well, I suppose, yes. I suppose you're correct, Judge, because
because she
because
said
there was no
details.
there was no meeting plan. It was so that she would have understood that there was going to be some sort of encounter.
Right. And then maybe I think it would also be the evidence was sufficient to infer, once they at least arrange and pick up, let's say, back up the other friend on the way over, and the defendant switches to the back seat, that there's maybe that agreement could extend to the idea that there's going to be trouble.
I don't know if that can be inferred. Maybe he wanted his girlfriend to sit in the front seat. I don't know.
Why did what inference are we capable of drawing with respect to, it's his car, he's driving it, they go over to Trammell's something place, they get Trammell, but he drives. This third party drives the car solely for whatever this errand is. There's a driver. He had to say something to the driver. Why are you having me drive? It's your car. Had to say something. Now, my hypothesis is that you can infer something quite serious, which is I need a driver because while I'm in the car, I can't be driving it. I'm going to be doing something with my hands, shooting out the window. Because if he was going to be dropped off, he could just park the car. Why do you need a driver unless you're going to shoot out the window? Over to you.
Well, I don't think that Kyla Spagmer, I think that's her name. I don't know that she could certainly.
No, but I'm asking about an agreement between Trammell and the defendant.
Well, I don't. I understand your view. I don't necessarily think that to determine that someone had a gun on them, I think is a leap, I suppose. Sure, is he maybe thinking of doing something? Sure. I don't know that there was any evidence that anyone knew that he had a gun on him. So I guess that would be my contention.
Why might do any other reason someone might need a driver?
I don't know. I suppose if he was planning to jump out of the car or what have you. But I understand your question as to whether or not they could have parked and then done something. I do understand that, but at the same time, I understand that it could be reasonable that he would want to just jump out of the car. I don't know that there was any evidence that he had a gun or that anyone suspected he had a gun.
We'll ask your brother about it. Your time has expired. Excellent argument, very helpful to us. And we will hear now from Mr. Charles.
Good morning. Thank you, Your Honor. Assistant District Attorney Jamie Michael Charles, appearing for Middlesex on behalf of the Commonwealth. I'll turn to the issue of the Rule 36 constitutional speedy trial claim first. And just to address the waiver question briefly, I think the fact that my brother referred to this record as convoluted numerous times during his argument sort of speaks to the point the Commonwealth was trying to make in its brief. And I also, while I'm not begrudging the defendant this, certainly even in his brief, there was not a lot of specificity in terms of which specific days were includable and excludable. And I would argue that it's probably because, as he says, the record was convoluted.
But the burden is on you, isn't it, Mr. Charles, to explain the delays? And if the record doesn't say why, I don't know why we shouldn't just assume, well, I'm going to add in that November to March period. I don't know what that is, but it's not justified.
So, I mean, I think it's clear from the Commonwealth's brief. I certainly am happy to defend the excludable periods. And I do, and just to be clear, Your Honor, because the indictment was on July 15th of 2015. The trial was on March 7th of 2017. And so by the Commonwealth's calculation, that's 602 days. And I think the Commonwealth has demonstrated that the vast majority of those can be excluded. But the point I just want to make on waiver before I move to the specific periods is, this court and the SJC have recognized that Rule 36 claim, I understand Your Honor was part of the Rondon decision, and I recognize that a constitutional claim cannot be waived. But from a Rule 36 perspective, where it's a case management tool, it's not a constitutional analysis. A defendant has to press the right. The only objection raised was on May 18th of 2016, a point in time at which 365 calendar days hadn't even elapsed since the indictment. So the only arguable claim at that point would have been a Rule 36C claim, and the defendant didn't articulate prejudice beyond he's held on bail, which is insufficient. So the defendant I'm sorry, Your Honor.
Even if Rule 36 is waived in the technical sense, wouldn't we still review for a substantial risk? And I noticed that all of your waiver cases cited in your brief were pre-Randolph, pre-2000.
Correct. That's correct, Your Honor. I did notice that, and so I did a little searching this morning. The only case I was able to find is Commonwealth v. Rooney, which is docket 18-1175. It's an unpublished decision from July of this year. And in that case, the panel cites favorably to Atkinson, which obviously is another pre-Randolph case. But in making the argument that the claim is arguably waived in that unpublished decision, this court cited Atkinson. So I would argue that this court still recognizes that in the context of a Rule 36 claim, you can waive it. It's somewhat akin to raising an ineffective assistance claim for the first time on appeal, where the record is not sufficient for the court to really make a full and fair assessment of who is responsible for what time period, particularly where the defendant hasn't pressed it below. So that would be the Commonwealth's claim. But I think if you analyze it under, I'm sorry, Your Honor.
Can we avoid all of this because of that September 15th to May 19th delay that was either mutually called for or acquiesced in? Is that enough days to get us to under a year? If those are
So yes, I think the short answer to that is yes. My calculation of that time period is 242 days. And if you subtract that from 602, you are now right under 365. You're at 360, I believe.
Yeah.
And I don't think there's any real dispute at that time. I mean, I don't need to get too into the weeds on it, but essentially the defendant fails to appear on a scheduled date. The next date is for motions for the defendant's benefit, which he declines to file. And after that, on the next two dates, the defendant agrees to continuances of the trial, and that's reflected in the docket. So at a minimum, that time period is excluded.
The constitutional claim, though, is on a slightly different footing and can't be waived. So if we were to conclude that it's not justified to keep someone from being tried for 6 months while you try someone else who's claiming a Fifth Amendment right not to testify, rather than immunizing them or not using them or doing something else, trying them together, I don't know, something. If we find that's not a good reason for a delay, are we in the constitutional speedy trial ballpark or not really?
It will not be surprising to you to hear the Commonwealth say that we don't think it would reach the level of a constitutional violation. If you look at the four factors, the length of delay here, again, was only 602 days. I don't mean to belittle it. It's obviously not particularly expeditious, but we're talking about less than 2 years, which falls far short of other cases that this court and the SJC has cited, 5 years, 7 years, where there wasn't a violation. The defendant didn't press his right. He only objected on one occasion on a speedy trial grounds, again, at a time when 365 calendar days had not passed. And he never again pressed the right. And we don't know if that was tactical or not, because there was no motion filed and there was no affidavits filed and no testimony taken. Nor was there a motion for new trial to assess any potential tactical decisions or ineffectiveness of counsel. So we simply don't know, but he certainly didn't press the right. And in terms of the reason for the delay, I don't mean to suggest in my brief or here that the fact that a witness invokes the Fifth automatically entitles the Commonwealth to kick the can down the road. But this was clearly an essential witness for the Commonwealth. Without Ms. Spangenberg, there was no prosecution. She's the individual who contextualizes the text, the Facebook messages. She is the individual who can testify to driving the defendant to the scene or to being in the car with the defendant when he is driven to the scene, and to Gordon Trammell having been picked up. She is the only individual.
Doesn't that just put the ball in the Commonwealth's court to decide that they need to decide what strategic choices they're going to make in the face of that witness's assertion of the invocation of her Fifth Amendment rights? I don't see why that is supposed to come at the expense of the co-defendant's Speedy Trial Right Act, speedy trial rights.
Mm-hmm. And I acknowledge that, Your Honor. I'm not suggesting that the Commonwealth can indefinitely drag a case on until a witness is available, but I think you have to look at the context in this case. From what I can gather from the record, this witness, while still being prosecuted as a co-defendant, had been cooperative up until March of 2016. And on the eve of the defendant's trial in March, she for the first time indicated that she intended to invoke her right. She had never previously asserted that she would do that. She had been cooperative with the Commonwealth. At that point, the Commonwealth rescheduled the defendant's trial to the May date with the defendant's agreement in anticipation of Ms. Spangenberg's trial taking place earlier in May. On the eve of her May trial date, for the first time, she indicates that she no longer wishes to have her counsel represent her, and she gets a new attorney. This is also 2 days before the defendant's trial. The Commonwealth learns of this for the first time. And so because she obtained a new counsel who had scheduling conflicts, her trial needed to be pushed out to the fall. It's certainly not ideal, and I don't mean to belittle a situation where a defendant is held on bail awaiting a trial. But again, at that point, we had not yet reached a year. She had previously been cooperative. The Commonwealth was definitively going to be able to resolve her Fifth Amendment privilege through trial. while certainly we could have immunized her, this
How
was a
do you know
serious
that
case.
would, how do you know that would resolve her Fifth Amendment privilege? You don't think there might be a federal claim here, a firearms offense? I mean, I have no idea, but I don't know that that resolves her Fifth Amendment claim.
I mean, I certainly don't have a thorough enough record to make a definitive pronouncement about that, but it certainly seems as though the judges before whom the parties appeared, including Justice Budd, accepted the representation that her privilege would resolve. And the Commonwealth also represented in that May hearing that while there was a new trial date scheduled for the witness, it did still anticipate reaching a plea agreement with her prior to that date. And so it was hoping to resolve her case one way or the other, whether via trial or plea by the fall, at which point she would be an available witness to the Commonwealth in this case. So while I'm not discounting Your Honor's concerns about delaying a trial for that specific reason, particularly if it were a longer delay, I think here where almost all the delay to that point had been due to agreements or filings that benefited the defendant, and where we're talking about a 4 or 5 month delay where we haven't even reached a year yet on the case, that certainly doesn't reach a constitutional violation where the defendant has not otherwise significantly pressed his case and where he hasn't demonstrated specific prejudice from the delay in terms of it affecting his case. And I think it's further complicated here by the fact that he files that motion to dismiss on McCarthy grounds in the fall, which essentially caps the clock because we're now in a position where the November trial date passed due to the defendant waiting a decision on that motion.
It's very tricky to, I find that very tricky. If he was ready to go forward in May, and then we were to find without good cause, there was a 6 month delay. And during that time, he files a motion. I almost don't want to get into it's like a
Fair enough.
problem. I'm not saying you're wrong. I just don't know. It's complicated.
That's a fair
Can we
point.
turn to the sufficiency of the evidence?
Yes. If I could just note one thing, Your Honor, and then I'll happily pivot to that. I would just note that the hearing before Justice Budd on the specific grounds for the continuance that the Commonwealth requested as to that witness was on June 23rd. And no transcript of that hearing was produced in conjunction with the appeal. So again, I would just note this is a situation where the defendant didn't provide a record that could have potentially illuminated what happened on that. It's quite possible on that date that Justice Budd found that this was a justifiable cause for delay, that there was good cause for this delay. But we don't know because we don't have that transcript. But pivoting to the sufficiency claim, I think Justice Rubin sort of hit the nail on the head that the Commonwealth was trying to set forth in its brief, in that you can clearly draw inferences from the circumstances here where the victim initiates at the defendant's request a Facebook communication with someone she has met only once and whose advances she had previously rebuffed. She arranges a meeting with that individual, at which point a third party, Mr. Trammell, is picked up, ostensibly for no other reason than to drive the defendant's car. And at that point, the defendant gets in the rear seat of the car. He doesn't even sit in the front passenger seat. He gets in the back of the car. And I think it's a fair inference at that point that he has moved himself to the back of the car for a specific reason, and that it is a nefarious reason, that is to shoot Mr. Feaster. Now, I understand that.
Curious, but what's the evidence that it was to shoot rather than to jump out of the passenger side rear seat and punch the victim in the nose, for example? We need evidence both that he was armed and that he had an intent to murder, and that was part of the plan, don't we?
So I would dispute that the Commonwealth essentially has to prove knowledge of all the elements of the crime. I think if you look at, just for one, the Commonwealth v. Stack, I didn't cite this in my brief, but it's 49 Mass App Court 227. I think it's from 2000. This court said that a conspirator does not need to be cognizant of every part of an agreement. The Commonwealth need only prove knowledge of the essential features or general aims. There was clearly an agreement here to go and do harm to Mr. Feaster.
But the punishment for a conspiracy depends on what the object of the conspiracy is, what crime it is aimed at committing. So necessarily, doesn't that require proof of each element of agreement on each element of the crime?
So I think what I'll say is that the Commonwealth's position is that the reasonable inferences from what happened encompass a conclusion by the jury that both Mr. Trammell and Ms. Spangenberg understood that this defendant was going to the scene to shoot Mr. Feaster. Are there other possible conclusions that could be reached? Yes, I'm not going to discount that. But I think one of the reasonable and possible.
Does the inference have to be? Does the inference have to be beyond a reasonable doubt? Do the jurors have to infer? I mean, I guess I see preponderance of the evidence. Although I do have to say, I assume that there have been times in the world when people have been a passenger and have hopped out to do something wrongful and hopped back in and sped away. And being the guy who has to go to the driver's seat and turn the car on and whatnot takes a little longer. I mean, I don't know, but you can imagine that. And now we have to get to infer beyond a reasonable doubt that it's with intent to murder. Is that right? Am I right about that standard?
I struggle with the standard for proving conspiracy. The case law has been less than crystal clear on exactly what has to be proven. Not to sidestep the issue, but I would just note that, while the Commonwealth feels that this was the evidence was sufficient, the defendant received a concurrent probationary sentence on this conspiracy count.
Hold on, before you go on any further.
Sure.
It's not a general conspiracy that he was charged with. He wasn't charged with conspiracy. He was charged with a specific conspiracy. And it seems to me that once the Commonwealth makes that choice, then it has the burden to prove beyond a reasonable doubt that that was the purpose of the conspiracy.
So I guess what I'll say is while Justice Rubin is certainly correct that we may not get beyond a reasonable doubt just from the arrangement in the car, the fact is that the defendant did shoot the victim from the rear of the car. He then dropped Mr. Trammell back off at his house immediately afterwards. Ms. Spangenberg didn't run away, didn't alert the authorities. She went back to the defendant's house with him and spent the night there. I think it's a fair inference from all of the circumstantial evidence that she understood what was going to happen and that she had no issue with what happened. And I think you can infer based on the arrangement in the car and how they set this up and the fact that she didn't flee or alert anyone after the fact, that she knew full well what was going to happen when they went to that location at Garden Crest, notwithstanding what she testified to.
Your time has expired. I have another question. Justice Sachs may as well. But let me just ask you this. If we find that element insufficiently proven, do we knock this down to a lesser included offense and remand for resentencing? Or do we just vacate that conviction? Do you have any idea? With
regards to the conspiracy count?
Yeah, because it might be, I mean, conspiracy to commit an assault, that you might easily get, for example.
I would say that I think the Commonwealth specifically alleged, as Justice Wolohojian correctly noted, this was not a general conspiracy. We alleged a specific crime, and I think you would probably have to vacate that conviction. I'm not sure the Commonwealth would contest you doing that if you felt the evidence was insufficient, because again, this was a concurrent probationary sentence with other terms. I'm not sure it would make sense for the court from a time perspective to go down and try and take further action in terms of resentencing.
Oh, right. So it wouldn't be a lesser include. We would not. So it wouldn't be a lesser included offense. So there would be no need to send it back down for resentencing.
Correct. I don't believe it would be. I don't know if Justice Sachs had a question, but if not,
yes. Criminal Rule 9E says that unless the defendant moves for joinder, then the conspiracy can't be tried at the same time as the substantive offense. So how did that come about here?
So because I'm not trying to pass it up, but because the defendant did not specifically challenge this, the Commonwealth does not have transcripts of all the pretrial dates. So I'm not sure if this was discussed on the record. While I recognize that that's what the rule says, my understanding historically, based on my experience in the trial courts, has been that if a defendant does not object to having the conspiracy tried with the substantive offense, courts will typically allow it to be tried with the substantive offense. And I do not see on the record that I have any objection at any point by the defendant to having the conspiracy tried together with the substantive offenses. But I obviously don't have a transcript, and the court doesn't have a transcript of every pretrial date in this case. So it's hard to say with certainty what exactly happened in that regard.
All right, your time has expired. We understand your argument as well. Excellent arguments from both of you. Very, very helpful to us. Some interesting issues here. So thank you very much. And
We are live and on the record.
good morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined by Justice Wolohojian and Justice Sachs. The next case we will be hearing today, I guess I should say to counsel, of course, we're doing this by video conference in light of the pandemic rather than in person. The rules are the same as for argument in the courtroom, which is to say 15 minutes per side, and there is no rebuttal. The next case we will hear is number 19-1664, Lawrence versus Swansea Water District. And we will hear first from Mr. Brennan.
Good morning, Your Honors. May it please the court. My name is Edmund Brennan, and I represent the appellant, Swansea Water District. The matter is before the court on appeal from a finding by the jury in Bristol County on a quantum merit claim for wages alleged to be owed by the plaintiff. The thrust of my appeal to the court, although there are numerous issues, the main issue, as I see it, is the statute of limitations defense. It was pleaded in the answer to the complaint, and it is the appellant's position that the plaintiff, Mr. Lawrence, admitted during cross-examination at trial that he had knowledge that Swansea Water District would not pay him for the claimed wages for overtime more than 6 years prior to filing his suit. He knew that based upon conversations with his superintendent and his immediate superior, as well as a written request that he made in June of 2007 at the annual district meeting between the commissioners and the employees.
If you don't mind my interrupting you, Attorney Brennan, why I understand how that goes to the question of the sufficiency of the evidence of a reasonable expectation of getting paid, like on the merits of the claim. If everyone told you you're not getting paid, you may expect it, but that doesn't seem reasonable. I get that argument. But why does this go to statute of limitations? That is, if in fact he continues to have a reasonable expectation and each week he doesn't get his overtime, why don't we just take the paychecks? I guess I would say the paychecks more than 6 years before he brings suit are excluded. I gather that's the remitter aspect of your claim. But why aren't the ones after that, if he in fact had a reasonable expectation, why aren't those still alive?
Well, my response, Your Honor, would be that we're using the term a reasonable expectation. This goes to some of the cases where there was actually a contract at issue, and there was a clear, unequivocal repudiation of the contract.
We're just talking about quantum merit here, though, because the
That's
jury
correct.
rejected the contract claim. And for quantum merit, there has to be a reasonable expectation of being paid, among other things. So if, and we're just assuming at this point, but if the jury had sufficient evidence to find a reasonable expectation, then why isn't the overtime that wasn't paid during the 6 years prior to filing a suit recoverable?
Well, I think it goes to the reasonableness of the expectation, Your Honor.
I ask you to assume that the expectation is reasonable. If it is, and we haven't decided whether it is or not, but if it is, why wouldn't those 6 years become?
If the expectation was reasonable and the other two elements of the quantum merit case were met, then I would agree with Your Honor that they could be compensable under quantum merit.
All right,
However,
well then why is it that that doesn't undercut, why doesn't that alone establish the proposition underlying Justice Rubin's question to you, which is that this really goes to the sufficiency of the evidence as opposed to the accrual of the claim for statute of limitations purposes?
Well, the sufficiency of the evidence, I would have to refer the court back to the testimony of the plaintiff, where he testified that he knew more than 6 years prior to filing suit that Swansea Water District was not going to pay him for this time. They weren't going to pay him. So he sat on his
I guess
rights.
another way of putting this is just imagine any kind of tort claim, doesn't matter what kind of tort claim it is. And the person loses, the plaintiff loses on that claim at trial. And an element of you couldn't say from the fact that they lost the case that the claim had accrued earlier and was therefore untimely when brought, right?
I would generally agree with that. Yes, Ron.
Okay, so why is it that that's different when the claim is unjust enrichment?
Well, meaning the quantum Merowith claim.
Right, sorry, quantum Merowith, yep.
I think the argument persists that I don't think I can separate the statute of limitations defense from the argument that his was not a reasonable expectation of being paid. They both carry equal weight. The plaintiff didn't prove, plaintiff proved that he didn't have a reasonable expectation.
Okay.
But if he alleges a reasonable expectation, right? Statute of limitations, you can decide on a motion to dismiss. So if the complaint says I had a reasonable expectation every week, then isn't the statute of limitations, at least for the ones up, 6 years or less behind, isn't the statute of limitations met, but the claim turns out to be on its facts a loser. But the allegation, I had a reasonable expectation every week, and yet they wrote me these checks that were too small, which we might say, yeah, but you didn't prove that at trial. Isn't that allegation enough to get us past the statute of limitations problem?
Well, the allegation was sufficient to get past my motion for summary judgment, yes. That's what Judge Dupree found when she ruled against me on summary judgment, that there was a genuine question of material fact in that regard. However, it still is the plaintiff's burden to prove compliance with the statute of limitations once it's raised by the defendant. And there are cases on quantum Merowith where the court found that the plaintiff sat on their rights too long, that the statute of limitations did bar their claim on quantum Merowith.
Is there a new claim for quantum Merowith with every new pay period?
I would suggest not. That's the rolling statute of limitations that's referred to, or continuing violation doctrine that's referred to in different cases. And I suggest that once the plaintiff knows that the other party, the defendant in this case, is not going to pay them for this alleged time on the computer, then they're right. They have an obligation then to pursue their right. There was a grievance procedure set forth in the handbook, employee's handbook. He didn't follow that. He didn't submit timesheets saying when this overtime took place. He admitted he did not do that.
Let's look at what the jury found regarding reasonableness. The judge instructed the jury on the quantum Merowith claim that, among other things, to recover the plaintiff's expectation of being paid had to be reasonable. However, the verdict slip in question 6 did not ask the jury to determine whether the plaintiff's expectation was reasonable. It simply said, did the plaintiff render services to the defendant with the expectation of being paid? And the jury answered yes. So given how the verdict form was set up, and if the plaintiff had a subjective expectation of being paid, which there certainly seems that there's some evidence that he did, how did the jury get it wrong? How are you entitled to a JNOV?
Well, I think I see your point, Your Honor, on how the jury question was drafted. But at the end of the day, the elements of the quantum merit, of proving quantum merit, and the instruction is a reasonable expectation of being paid.
Sure, but
And-
has that issue been waived? Or put it this way, what controls, the judge's instruction to the jury or the special verdict form, which I assume was agreed upon by the parties and approved by the judge?
The special verdict form was agreed upon by the parties, that is correct. But I think the instruction to the jury as to what the law is still controls.
And what's the authority for that?
I haven't briefed that, Your Honor, so I cannot point to authority to support that position.
Could you turn to the actual mechanical calculation of the damages? Can you explain the math that underlies your contention that of the amount that should be remitted, the 21,000? Can you tell me the date you're going back to?
Going back to the date of his hire, which was July 26th of 2006, to a period running 6 years back from the date they filed suit. So we're saying that if there should be a remittiture in the amount of that exceeds, that was calculated outside of the 6 years from the filing of the suit, which was on in November of 2007. So when you go back,
So you're saying the 21,000 is all for time more than 6 years before the filing?
that's correct, which I would describe as outside the statute of limitations.
Your calculations make some intuitive sense, but how do we know that that's what the jury did? The jury awarded a lump sum. It didn't set forth its calculations. And if somehow it had found that the entire $69,000 that it awarded was due only for those claims within 6 years prior to filing suit, there's no ground for remitter, is there?
But no, but what I did the math based on the testimony of the plaintiff. And his testimony of the plaintiff was established $300 per week. And when you apply that $300 a week.
Were the jurors instructed not to award for the time period before 6 years? Did you ask for such an instruction?
I believe they were, Your Honor, in the jury instructions, that he would be entitled to recover within a period of 6 years from the filing of the complaint.
Did
I
you
do believe
offer a
that is
number?
correct.
Did
I'm
you
sorry, Your
offer?
Honor?
I can't remember if you offered a number to the jury in your closing for what the damages would be that were within the statute of limitations period.
Well, no, as the defendant, Your Honor, I argued against anything.
Right. So
No,
then,
no. Plaintiff, I would have to defer to plaintiff's counsel on what she suggested the damages should be and the time period. But I can't point to the record, but I do recall seeing in my notes that the judge did instruct the jury that the recovery period would be limited to the 6 years prior to the filing of the complaint.
So if we presume that the jury followed that instruction and yet somehow came up with the figure of $69,000, what's the ground for the remitter?
Well, there was no mathematical formula. You're correct, Your Honor. So I'm using the plaintiff's testimony and the award to us that is $300. It just works out to within several $100s of the $69,000. So that's how I arrived at that. And it seems like the jury applied that formula to the damages.
but you did not offer that formula. Did anyone offer that formula to the jury?
The plaintiff did in his testimony that he worked 8 to 10 hours per shift overtime at $30 per hour. So he was establishing the $300 per week in overtime not compensated for. And when you do the math for the time that he worked at the district, it comes out to the $69,000.
Can I ask you a question about the limitations on impeaching the witness Bacon?
Yes,
You've argued that your client was prejudiced by the judge's refusal to allow Bacon to be impeached with evidence that he had voted to appeal the Department of Unemployment Assistance's decision to the district court. So how would allowing him to be, what would allowing him to be impeached with that evidence accomplish? What aspect of his testimony would it have impeached?
It would have impeached his testimony that the stipend that was paid to the employee was merely to be on call and ready fit for duty, and that anything done on the computer, responding to the computer, would be compensable as overtime, when in fact he voted to appeal that exact issue.
But he might have had a variety of reasons for voting to appeal. And
But I wasn't even allowed to ask him, inquire into that. Any evidence of the,
if you had been allowed to say, isn't it true, Mr. Bacon, that you voted to appeal that DUA award? He would have been allowed on a redirect, at least, to say, well, here's why I appealed it. It wasn't the particular issue of the amount of the stipend. It was some institutional concern that the water district has that has implications in future cases. And wouldn't his explanation have inevitably led off into collateral issues about what had happened in the unemployment proceeding and what the various issues were there that would have resulted in some jury confusion? So I guess the bottom line question is, couldn't the judge in her discretion or in his discretion, I'm forgetting now,
sure,
that this is, will tend to confuse the jury more than it will benefit the jury?
well, I think it would have been fertile ground for cross-examination, Your Honor. The minutes that when they voted to appeal the unemployment case were concise, and I don't think there was any other reason why, and I should have had the opportunity to ask him that. There were other issues that would have come up that I'm aware of that would have opened up on cross-examination that would have certainly challenged his credibility and established animosity towards Swansea Water District as a former commissioner. That was where I wanted to go with that.
Your time has expired, although if there are further questions, no, seeing none, thank you very much.
Okay, thank you.
Excellent argument, interesting. We will hear now from Ms. Carlson.
Good morning, Your Honors. I'd like to start with Mr. Bacon's testimony, and we can work our way backwards. Mr. Bacon testified that he was told by Mr. Marquise that the Water District employees were only on the computer momentarily. He was never informed that they were working hours, and it's in his testimony. So I would submit to the court that if Mr. Brennan was able to raise the issue of the unemployment issue, he would have said, yeah, we voted to contest it because our understanding was that they were paid for all of the time that they worked overtime, and that if they were on the computer, it was only momentary, and that's what his testimony.
I don't remember the order in which things happened, but weren't they asked whether they should get overtime before the appeal, before everything? Wasn't the Water District, while he was on it, specifically asked to change its policy to allow him to be paid for overtime work he was doing?
No, the policy was always that he should have been paid overtime. The policy was in the book. The policy was always that he should have been paid overtime.
And yet he was repeatedly told he wasn't, and I thought he brought it to the Water District, which did not vote to allow the employees to be paid for that.
But the reason that they did not, they didn't vote not to pay him. Mr. Bacon testified, and it's at page 363, I think, of the appellate court papers. Mr. Bacon testified that when they raised the issue, they got a list from the employees that said, hey, we want these items. They went to Mr. Marquise afterwards and said, what's with this? They want to be compensated. And he said, oh, that's covered by the stipend. It's only momentary when they're on the computer, 5 to 10 minutes. Mr. Bacon also testified that it was his understanding that if they were performing overtime work, they were being paid for it. My client testified that not every time, but he continually requested to be paid the overtime. And he said that he did it over a number of years. He requested to be paid overtime for work that he performed at the location and on the computer. And Michael Bacon, who was one of his supervisors, would crumple up the request, throw it in the trash. The reason my client kept asking for the overtime is that he had an expectation that Swansea Water District would follow A, their own policies and procedures as outlined in their handbook, and B, that they would follow the statute or the law that required them to be paid for the overtime.
Well, there's a finding now that he wasn't required to be paid for the overtime, right? So let me ask you this.
I'm sorry, there was a finding that he was not required to be paid?
Contractually not required.
Statutorily, that under the Wage Act, he didn't have to be paid overtime for this, right? That's what the prior proceeding was about.
No, the prior procedure was about, in the appeals court, was only, and the appeals court decision says, the issue is whether the employee established by substantial and credible evidence that he had good cause for leaving.
Yes, but the reason he didn't have good cause is he wasn't denied payments to which he was entitled under the Wage Act, right? That's what the agency concluded, right?
He wasn't able to prove that he was entitled to overtime because.
Okay, so now, given that finding, so that we can't rely on the statute, what evidence is there in the record that and I understand, actually, let me ask this in two parts. First question, do you believe that you had to prove that he had a reasonable expectation of getting paid?
I think we did, yes, and I think we did that.
Okay, what evidence supports that it was reasonable, given that he was told to stop doing it, that the board voted not to give it to him, that he knew he wasn't getting it, and we can't put in the statute, I don't think, although we'll have to figure that out, because there's now a holding that the statute didn't require it.
Okay,
So go
so
ahead.
two things. Number one, I think his expectation of being paid was reasonable because the employee handbook outlined the fact that he should be paid overtime.
Okay, but he's an employee at will, right?
He is, but
So
there
they can change that policy anytime they want, and he's asked repeatedly to be paid, and they've said no.
But they did not say no. I disagree with you that they ever said no. Mr. Bacon's testimony is that the board understood that if they were working anything over 40 hours a week, they were being paid for it. That was the board's understanding.
Then
His understanding.
Why did Mr. Bacon crumple up the
There's two
submission?
Mr. Bacons here. That's one of there's two Mr. Bacons. Mr. Ernest Bacon was a board member. Mr. Michael Bacon that crumpled up the paper was a supervisor. So there's two Mr. Bacons in this case. It gets a little confusing. Ernest Bacon was on the board and he testified that when they questioned Mr. Marquise about the employee's request for overtime, Marquise told him it was only momentary. So they didn't address it. They didn't, one way or another, it didn't appear in their final decision. They didn't deny it. My client understood that it wasn't addressed and that he wasn't going to get money up until that time in 2007. And keep in mind, the board changes every 3 years. So they kept asking.
Wait. Once he understands that he's not getting the money, how can he reasonably expect to get the money?
Because he only understood that he wasn't getting the money for that period of time. So
are you saying this is sort of a week by week thing? He can reestablish his expectation every week?
I'm saying that although he understood that they weren't going to pay him at that time as a result of the end of the board meeting, he didn't feel it was correct. He didn't feel that was a right decision. And he felt that he was in accordance with the handbook that never changed.
All
He
right,
was
so can
supposed-
I'm going to ask you a variation of Justice Rubin's question, which I would appreciate if you could just, in answering, point to specific pieces of evidence.
Okay.
What was the evidence that you are relying on to establish that your client's expectation was reasonable? I take it one of it is the handbook.
The second one is that they brought it to the board again in 2010. Shane Hennigan testified that he was involved, that he also had been working overtime, that he had been requesting the overtime and denied it, and that he also brought it to the board in 2010 with the expectation that the board would come back and pay them for their time on the computer.
But that's a subjective expectation. Once they've said no, I understand he hopes that they will change their mind. But until they change their mind, isn't his expectation just hope?
I don't believe it is, because at that time, nobody told him that they were intentionally going to go against the handbook, and nobody told him.
What did he understand the 2007 decision to mean, aside from we're not paying you even though it's in the handbook?
He didn't get a decision in 2007. They didn't. He was never told directly, and it's actually in the transcript. He was never. It wasn't included in the minutes. It wasn't included in the board's decision. The board came out with a compensation package that didn't address the overtime. So my client, although he didn't get it, he felt that because he was entitled to overtime, he was an hourly worker, he submitted for the overtime, he constantly submitted for the overtime. It was an ongoing issue and battle. He expected that he was supposed to be paid. The employees had a number of conversations between themselves, and he testified to that, about the fact that he should be paid overtime.
Normally, these quantum merit cases turn on what the defendant did to set the plaintiff's expectation of payment. Do you see what I'm saying? It's not just what you think in your own mind about how you should be paid. It's what the payor does or says that leads you to think that. And what I hear you saying is that the one thing there was the handbook.
The other thing is the decision in 2007 that came out as a result of that meeting, actually it came out in 2008, was void of any mention of the overtime. It didn't mention it one way or another. It didn't say anything.
But they didn't start paying him. So surely he understood that his request had been denied, no?
No, that's not true, because they did pay him. They paid him when they felt like paying him for the time that he showed up at the plant. He testified he got about $6,000 worth of overtime, but he also testified
for working on the computer. All we're talking about is overtime, not at the plant, working on the computer.
But Your Honor, if I may, my client's expectations were the same for all of the time, and the employer crumbled up pieces of paper for overtime that were for time at the plant and time on the computer, making no distinction. It was I want, if you
Which
would,
would
if you mind.
undercut any expectation. I don't see how that helps you, frankly. Because if your employer is denying your requests for overtime, how is it that you then have a reasonable expectation that they're going to pay you for your time?
Well, I think the reasonable expectation from the employees, and that's why they continually asked and then went back to the board in 2010, was because the statute required them to pay them overtime for any work performed after 40 hours.
It did not require him to be paid anything. There's a ruling that we can't change about that. He was found, there's no Wage Act violation here, right?
I don't believe that that's true. I don't believe that the Division of Unemployment can make a determination on a Wage Act violation, because if they had found a Wage Act violation, they can't award benefits or they can't award damages.
No,
or
but they
liability.
can say there was good cause for leaving, right? So it's necessary to their decision.
No, he was, I disagree, Your Honor. The Division of Unemployment was only able to establish whether or not he had good cause. It was not able to establish whether or not the employer broke the law or
Has he
violated.
ever brought a suit for payment under the Wage Act?
I believe that even under the Wage Act, the Division of Unemployment only can determine whether or not the employee had good cause to leave the employer's employment. They cannot determine questions of law or questions of fact, whether or not there was a violation of the statute. That's a question for the jury. That's not for unemployment. And I think that the case law on that is very, very clear. And that's why my client, his expectation was reasonable and it continued. And don't forget that the decision by the Division of the Appellate Court and unemployment didn't come for years later. So his expectation as he was still working there was he believed that in accordance with the law, in accordance with the handbook, in accordance with the procedures that he was supposed to follow, the employer was at its own discretion deciding when they would and would not pay him the overtime. And I think that that's very, very clear. The
Okay,
Division of Unemployment.
your time has expired. I do have one more question though. Was a Wage Act claim ever brought on your client's behalf, asking
No.
that he be paid overtime that he was denied?
Your Honor, I wasn't counsel for my client back at that time, and that claim was not brought, and I can't. There's another matter pending on that.
What do you mean? There's another matter pending on that?
There's a matter pending against the other attorney regarding that issue.
There is a malpractice action pending against the lawyer who failed to bring the Wage Act.
That's correct.
Fascinating. All right. Does anyone have any further questions? All right. Your time has expired. This is a really interesting and unusual case. So thank you both for excellent arguments. Very helpful. Welcome to the Appeals Court. I'm Justice Rubin, and with me are Justices Wolohojian and Sachs. Our rules on this video conference, in which we're engaging due to the pandemic, are the same as the rules that we have for in-person argument in the courtroom, which is to say 15 minutes per side and no rebuttal. The next case we will hear is number 19-1464, Ferrier and others versus Comcast Corporation. And we will hear first from you, Mr. Morneau.
Thank you, Your Honor. Members of the panel, may it please the court. My name is Jeff Morneau, and I represent the plaintiff's appellants in this matter. This appeal challenges the Superior Court's conclusion that Comcast proved that the arbitration provision contained within its 2015 online subscriber agreement or any other arbitration is valid and binding on each of the plaintiffs in this case. There are multiple problems with the Superior Court's findings. The most obvious is the Superior Court's failure to apply the reasonably communicated standard that is required in Massachusetts for an arbitration provision or an offer to be valid. The reasonably communicated standard, as this court knows, was applied in Wolohojian, has been applied by Massachusetts courts prior to Wolohojian, has been applied by Massachusetts state and federal courts since Wolohojian, including in the First Circuit decision in Cullinan.
I'm sorry, is your position that even those people who have not put in affidavits saying they didn't receive the welcome kit, the 2007 or 2008 billing inserts, that even they under Wolohojian have not been reasonably communicated with, or is it only the 2015 agreement that was not reasonably communicated to them?
Your Honor, none of the agreements were reasonably communicated. None of the arbitration agreements. If there is and there are plaintiffs that have not submitted affidavits, perhaps in those particular circumstances, Comcast has met its burden of proof. But with perhaps at best, but I don't think so.
Let me see. Ferrier, Payero, and Bogdanovich, at least by my count, did not submit affidavits.
That's correct, Your Honor. Everybody else did submit an affidavit.
All right.
There's a fourth who didn't.
Who else? Oh, Govoni.
Govoni, the estate of Govoni.
Yeah, so those 4 did not submit affidavits. Did any of the plaintiffs who submitted affidavits continue their service, their Comcast service, into 2015 at the time of the latest contract?
Yes, Your Honor. There were some of the plaintiffs. I'm not sure exactly which ones had continued their service into.
But do you know which ones who submitted affidavits did?
I do not, Your Honor.
Mr. Morno,
I don't have any dispute. There's no dispute really with regard to the accuracy of the Ziegler affidavit that was submitted with regard to when the plaintiffs have service. And the Ziegler affidavit, I believe, is at RA 74 through 78, which I think outlines when people started and ended various service.
what is the dispute of material fact as to the 4 plaintiffs who did not submit affidavits that made it erroneous for the judge to order arbitration, at least as to those 4 plaintiffs?
With regard to those 4 plaintiffs, there's no evidence in the record with regard to those 4 particular plaintiffs that they actually got anything.
Okay, why can't we rely on the Kane declaration of Comcast's having regular business practice to give them a welcome kit that includes the subscriber agreement, which creates a presumption that the business practice was followed in this case. And so they received the subscriber agreement, which said, if you accept the services, you accept the terms. Why isn't that enough for those?
Sure, Your Honor. There's multiple problems with the Kane affidavit. The first is that it's really not based on any personal knowledge.
He doesn't have personal knowledge of Comcast's regular business practices?
Well, no, Your Honor. With regard to the regular business practices, I think we raised multiple issues with regard to that affidavit. The mere fact that there may have been a regular business practice in point at some time where they mailed or they through these welcome kits they gave subscriber agreements. We don't know what those look like when they either came in the mail or when they were delivered to the customer. So for example, they claim that the welcome kit was delivered at installation. We don't know, and there is no evidence as to what that welcome kit looked like. Comcast didn't submit the welcome kit.
She says in her declaration, which by the way, she says at the beginning, she knows as of her personal knowledge, that the subscriber agreement is included in the welcome kit when they initiate service. And there's several copies of the subscriber agreement from various times here that all include an arbitration provision. And I believe they all include a waiver of class arbitration, although that's not the key point. So why isn't her affidavit enough to establish that those 4 plaintiffs received notice through the welcome kit?
Okay, so the affidavit, one thing the affidavit does not say that it would need to say is that the subscriber agreement that was actually given contained an arbitration provision. And nowhere.
But every copy of the subscriber agreement that's in the record does, I believe there's information in her affidavit saying that every other subscriber agreement has. So isn't it up to the plaintiffs to come in and create an issue of fact about that. Otherwise, why isn't her affidavit sufficient?
Well, the affidavit, I don't think that the affidavit does say that the subscriber agreements that were given contained an arbitration provision. She merely says that they were.
The subscriber agreements record, they speak for themselves.
But what's important is the way in which the arbitration provision is reasonably communicated and whether
We're back to reasonable communication. So your position is, if I'm not mistaken, although I didn't really get this from your brief, your position is, even if you got in the mail a subscriber agreement that includes an arbitration provision, that is not adequate, right? Or if you got a welcome kit when you install that include an arbitration provision, not adequate. What authority do you have for something being physically mailed to someone? I get that it's in fine print on page 326 or what, it's not that long, but you know, whatever, I get that. But what authority do you have for that isn't a reasonable way to communicate? I'm not saying it is as a matter of like colloquialism or whatever, like as a legal matter.
Yeah, Your Honor, I would refer you to the Campbell versus General Dynamics case. And I know that that's slightly different in the sense that it's an email versus the mailbox rule. But the mailbox rule that the defendants that Comcast is relying upon is antiquated. And when you look at the Campbell versus General Dynamics case, which is similar to this case, the employer sent an email. There's no dispute in the record. The employer sent an email. It got to the employee's inbox, and that's it. That's the mailbox rule. It got there.
Why
but that doesn't mean
talk about emails here when there's evidence of physical delivery.
Your Honor, I would dispute that they're physical delivery of what? Of this.
So let me ask you, I'm trying to figure out what would be good enough. So for example, because I can't figure out how to make it electronic and in some ways I don't want it. American Express sends me a letter, I don't know, twice a week, telling me about changes to my agreement. Okay. And I suppose if I went through them, I'd see they seem to have something to do with interest rates sometimes. I don't know what they say actually, but they are a separate mailing about a change in my agreement. Is that enough?
I guess the short answer is it depends on what the notice looked like when it came to you. So a reasonable communication, you have to look at not just the method, mailbox, email, website posting, but you also have to look at the form and the content and the layout and
okay,
the
so
now
I have a cable company and I have 30 million subscribers or whatever. And I need to let them know what the contract is. And the contract isn't just an arbitration clause, right? The contract is, we give you services, you do this, we do this with your information. You can't do that with the box we gave you. The remote control remains ours. You have to pay. If you don't, this is what will happen to it. How should that be communicated?
It can be communicated in a number of different ways, but if they're going to communicate it in the way in which they did communicate it, and on top of that, have the acceptance be some type of silence, some type of inaction, some type of either receipt of service or continued use of service.
That doesn't sound
You better make sure that the person received really good notice.
So wait, so is this a contract of adhesion argument? Like, are you saying that the terms have to be bargained for or something? I mean, I can't quite, I mean, I hear what you're saying, but just to give an example. Oh, yes, Justice Wolohojian.
I have since we're mired in the question of what is reasonable communication, I have a question about the standard of review. This is, it seems to me, a motion to compel arbitration is fairly akin to a motion to dismiss for lack of jurisdiction, for example. So in other words, you're not limited to the pleadings. You don't take the factual information in the light that's most favorable to the plaintiff. The judge is required to make factual determinations. And on appeal, we would normally defer to those. Can we not understand this decision to, in some sense, embed a finding by the judge below that the terms of these subscriber agreements were reasonably communicated, given the affidavit from Comcast?
Your Honor, I don't think so.
Why not?
The judge in this case didn't, in the opinion, didn't even mention Wolohojian, did not use the words reasonably communicated, did not perform an analysis as to how any particular arbitration provision was actually reasonably communicated to any particular.
But isn't that somehow, can't we find that to be implicit once she found what those agreements, how can you understand her decision unless that's what actually happened?
Well, I think footnote 3 in the opinion says something about that. And the judge in this case, I think, admits to the error when it says, I do not find it necessary, and did not analyze whether or not the 2015 online subscriber agreement applied to any particular plaintiff.
That's right. That's a different question. That's a different question. She did, but once she found that the essential term regarding arbitration was the same in all of them, how is it that we can't also understand that finding and her conclusion to rest upon a finding that the arbitration provision had been reasonably communicated?
I don't, because I don't think that the opinion actually says that it was reasonably communicated. It just says that it merely existed, and that I think is what is in the holding. The Superior Court actually said.
Let's say that we were, sorry, let's say we were to disagree and to say that the only way you can read this judge's conclusion is to imply an implicit finding that it was, these agreements were reasonably communicated. We review that for what? Clear error?
Yes. Yes.
Okay.
Why are you saying yeah, the reasonableness standard is a legal question, isn't it? Not a factual question. When we ask whether someone had reasonable suspicion, we don't.
No, reasonably communicated. Well, I don't know. We don't need to debate that here, but I just asked the question, and
it seems like reasonable. It seems like from the decisions that I've read, it seems like reasonable communication is something that is determined. It has to be based upon the evidence before the court. And I guess there's a question about whether or not the evidence that the court can consider includes not only the actual evidence and affidavits that are submitted, but also the allegations in the complaint. I think that appears to be an open question.
Okay, your time has expired. Are there further questions, though? No. Okay, thank you very much for an excellent argument. We will hear now from your brother.
Good morning, Your Honors. Adam Caldwell on behalf of Comcast, and may it please the court. The record firmly supports Justice Sweeney's findings of 1, a contract between Comcast and the plaintiffs in the form of Comcast subscriber agreement. 2, that the subscriber agreement had a binding agreement to arbitrate. And 3, that the plaintiff's claims were well within the scope of that agreement to arbitrate. Having made those findings, and given the limit.
Making findings, doesn't the case law say that a motion to compel arbitration is similar to a motion for summary judgment, in that if there are no disputes of fact, then the judge immediately decides whether you're entitled to arbitration or not. If there are disputes of fact, then the judge is supposed to expeditiously hold an evidentiary hearing and resolve them. So I don't understand a judge on summary judgment to be making findings, and since there was no evidentiary hearing here, I don't understand her to be making findings. Isn't the question whether there's an issue of material fact, and we have to construe the record in the light most favorable to the plaintiffs?
Right. There is no material fact in dispute. I mean, keep in mind that
As to the 6 plaintiffs who filed affidavits who said, that's not my signature on the work order. I never received the arbitration notice in the mail. I never received the March 2008 subscriber agreement in the mail. That doesn't create an issue of material fact?
It doesn't, Your Honor. And here's why. Because that's the mailbox rule creates a presumption of
The
receipt.
mailbox rule, the bills can be sent either by mail or electronically, says the Kane Declaration. She doesn't give any indication of whether any of these particular plaintiffs received their bills by mail or electronically. If they went electronically, then there's no benefit. You don't get any benefit of the presumption of the regular operation of the mail, so the so-called mailbox rule. So I don't see where we can presume, where the plaintiffs deny that they received those, that nevertheless they received them.
They did, she says very clearly that the 2007 standalone arbitration agreement was mailed to every Comcast customer across the country, including to Massachusetts.
No, she doesn't, Mr. Caldwell. She says, in July 2007, Comcast sent a notice containing the full text of the arbitration provision to subscribers in Massachusetts with their monthly bills. And in the preceding paragraph, she says subscribers can get their monthly bills through the U.S. Postal Service or electronically. That's page 81 of the record appendix.
Yeah, she says they sent them with their monthly bill, and she attached both of those, and those were both mailings. Those are both mailed.
Say,
How do we know
Justice
that?
Sachs, yeah.
Those I
doesn't say that every one of these plaintiffs received their bill by mail.
But the 2007 and 2008 agreements were mailed to every customer, including in Massachusetts. They were mailed hard copy, and that's why. And
her affidavit doesn't say so.
And that's why we have the hard copies in the record. That the hard copies were mailed to every customer because the arbitration.
Where does it say that in the record?
Well, it says sent. You're correct. It does say sent. This issue.
No, but it doesn't say sent. It says with their monthly bills. It does say sent, but it says with their monthly bills for the period. So does that mean, given the preceding paragraph of the affidavit, that if the person's bill was if they get their bill electronically, that the 2007 arbitration provision was sent electronically?
In the light most favorable to the non-moving party.
It means, I happen to know that those were sent by U.S. Postal Service.
It would have been good if that was in the affidavit.
It is also true that they currently say that they can get their monthly bills electronically, but those were mailed. This is the same issue. This issue was also, and Ms. Kane provided a declaration in the earlier case, the Askins case, same folks.
But there were no affidavits from the plaintiffs in that case. I don't view that as really providing much guidance. Or
also, can I ask you this? Is the mailbox presumption irrebuttable?
It's not irrebuttable, but the opposition to it has to be clear and unequivocal. And here, the opposition clearly is not clear and unequivocal, because besides the Comcast evidence, we also have the plaintiff's allegations in their amended complaint about these documents. Okay, so that is at pages 12 and 13 of the record. Now, this is interesting because here they claim they don't have notice and they couldn't have had notice. But in their own complaint, they say in 2003, and this is page 13 of the record, at paragraph 21 of the first amended complaint, that Comcast sent some of its Massachusetts customers a subscriber agreement containing an arbitration provision in 2003. Some didn't get it. In 2007, Comcast sent some of its Massachusetts customers a notice containing the full text of an arbitration provision as a bill stuffer.
Some,
With their monthly bills.
As a bill stuffer. That's not by mail. As a bill stuffer.
Some.
I mean, excuse me,
Some.
that's not by email. That's not by email. That's by
Some.
mail.
Some.
And then in 2008, Comcast sent a written notice containing the full text of their subscriber agreement to some of the subscribers in Massachusetts as a bill stuffer. And then some of them, what some means is that some of them submitted affidavits saying, I didn't get it. But you know, we run into this all the time, this I didn't get it defense, right? And it's not, it's.
and one of
But
them,
why,
I see you rebutting that argument in other cases, but not here, is by demonstrating that the particular plaintiff paid the bill for that month, which is clearly within Comcast's ability to offer evidence of, which wasn't done here.
Well, the Comcast subscribers, I mean, to your Honor's question about who's still a customer.
No, that's not, I'm sorry, Mr. Caldwell. That's not what Justice Sachs is saying. He's saying they paid that bill. They didn't have a late bill and pay the next one, so maybe they never got that one. It's evidence that they got it, the fact that they paid it, although they could rebut that by saying, I have auto pay. A judge has to sort it out, don't they?
Well, and let's not, we've gone over the facts or ignored the fact so far that when they initiate service, they also get the agreement in the welcome kit. Now that's a hard copy document.
Yeah, some of them, but we're talking about 6 plaintiffs who denied receiving that.
They denied receiving it, but they signed work orders saying now they deny it's their signature.
Yes,
But,
well,
you know,
that's why we have trial courts.
Right. Well, let's talk about the evidentiary hearing for a moment, if we may, because it seems like that's a point of interest. You know, Justice Sweeney held a hearing on this matter. She held a hearing on this matter. I was there, and nobody offered from the plaintiff side any evidence. They didn't say, may we call a witness? They didn't say, I'd like to cross-examine somebody. They didn't ask for anybody to be there.
Their papers did ask for an evidentiary hearing.
That's absolutely correct. And when
and what did Judge Sweeney schedule?
She scheduled a hearing. I went there prepared to cross-examine plaintiffs if they showed up, but none of them did. And where would it have gotten them, Your Honor? Because all they would have said is, again, I guess, well, I didn't get it.
But that's what credibility judgments are for. I mean, I get that it's another hoop to jump through and that you're fairly confident or supremely confident that ultimately you will get the findings of fact that you need in order for this to go away. But, you know, we got to cross the T's here, don't we?
And I think, yes, we do have to cross the T's and we have to dot the I's.
And it's not just pro forma in my view, because there is an important distinction between the language of the arbitration clause in the earlier agreements and the 2015 one. So one of the things that needs to be determined in my view is who was subject to the last of the agreements.
Well, let's talk about modifications for a second. I want to pull the lens back a little bit on modifications, okay? Because first, I want to make the point that Ms. Kane does say in her affidavit that the 2011 arbitration provision at the beginning of this case stems from this awful storm, late October, heavy snow, you know, leaves still on the tree, October 2011. She says the arbitration provision was identical at that time. So here's, and this goes
No,
to,
but did it have does that one, do the earlier ones talk about whether class action can be pursued in arbitration?
They did. They all had a class action waiver. Okay, each of them had a class action waiver.
I think you look at the record subsection F of the 2007 agreement, I think it is, that's referred to that may contain such a thing, but I think we don't have that. I think
you don't have that. That's referred. I think that's referred to in the complaint. But all of them had an arbitration provision. The dispute was within the scope of all of them. Now, at that point, making those findings, Everything else really is for the arbitrator. And this is important with respect to modifications, okay? Because we've argued that they're all bound to those modifications, but let me pull the lens back a little bit, because they're arguing that, well, you are allowed to unilaterally modify the agreement, and that makes it illusory. That makes the contract as a whole illusory. And you didn't follow your modification standards. But that is not an issue for the court to decide. And this is very, very clear. When a court is looking at a contract that contains an arbitration provision, there's a question about the contract and there's a question about the arbitration provision. Challenges to the contract as a whole are for arbitrators to decide. Challenges to an arbitration provision are for the courts. The validity of the arbitration provision are for courts to decide if there's no delegation clause, okay, which there is here. But challenges to the contract as a whole are for arbitrators to decide.
I'm sorry, I just don't follow what you're saying. Let's pretend there's someone who just got the 2007 one in the mail. That's what they got. The judge says, the judge, not the arbitrator, the judge doesn't say, for them, it's the 2007 clause. Or, you know, and now the arbitrator can decide whether different things about the contract and its modification and so on. But we start with the 2007 and we send it over to the arbitrator. She found that it's all the 2015 contract, and we happen to know, I think, that the arbitrator took that as binding. How shouldn't it be? I hear what you're saying, but doesn't that mean it should be parsed a little more fine than that? Well, the judge should figure out which one.
Because how can anyone who terminated their service before 2015 be bound by a 2015 agreement?
Anybody who terminated their service before 2015 would not be. But again, that's why we made the point in the Kane Declaration that the 2011 provision was the exact same as the 2015, including with respect to class action availability. And I just want to point the court to Prima Paint versus Conklin and Floyd, and then Buckeye check cashing. Those are United States Supreme Court decisions where this distinction between challenges to the contract as a whole and challenges to an arbitration provision is made. The modification provision of the subscriber agreement is not part of the arbitration provision. It's never been part of the arbitration provision. It's part of the contract as a whole. So if you want to challenge modifications, you have to, that has to go to the arbitrator.
So if there is a contract with an arbitration agreement applicable to each of these plaintiffs, the question of whether it was or wasn't modified or how is for the arbitrator. I get that. But I guess you are agreeing that although you think it's harmless because the provisions are the same, you are agreeing that the judge is wrong then to have said that the 2015 one applies to all of them because it's a modification to their contracts and the arbitrator needs to decide whether that modification in fact is binding. Is that right?
I think what the judge says was, I have these agreements in front of me. I believe the most recent one applies, but I know this, all of these folks took the service. They all took it pursuant to this contract. And the contract, all of the contracts have an arbitration provision and the dispute is within the scope. So I don't need to decide your argument. You can raise that. You can raise that. You can raise your class action arguments. You can raise all of that with the arbitrator. Okay. Now, if there's a problem with Justice Van Gessel's decision on arbitration, that can come back. And the reason it should happen this way, is the liberal, strong federal policy in favor of arbitration. When there's a chance that you could err on one side or the other, should we impose a judicial framework and certainly deny the parties the benefit of arbitration, or should we send it to arbitration and have it come back?
We are intimately familiar with the arbitration.
Yes.
Thank you very much. Your time has expired. If there are no further questions, very, very interesting case. No other questions that I see, so the case is submitted. Thank you, counsel.